Namaskar children. Today we will be doing our last right, that is right to constitutional remedies. Dr. B.R. Ambedkar said this right as heart and soul of the constitution. It is one of the important fundamental rights. This right gives a citizen the right to approach a high court or a supreme court to get any of the fundamental rights restored in case of their violation, and the supreme court and the high courts can issue order and give direction to the government for the enforcement of the right. That means, supposing if an individual is finding that he is deprived of the fundamental rights or he is denied the fundamental rights, what can he do? Only through this right he can present the matter in the court. That is why it is called as heart and soul of the constitution. Supposing if this right would not have been there, so the fundamental rights, they were of not much use, because if these rights are violated, we need a right through which we can approach to the court. So approaching the court to get the rights, it is done only through right to constitutional remedies. As I told you, the constitution has given power to the Supreme Court and the High Court to see the matter and give orders to the government. So this is called as writ, W-R-I-T. So what does writ mean? Writ means the power given by the constitution to the Supreme Court and High Court to see whether the fundamental right is violated and to take necessary action. There are 5 writs, and the first writ is writ of habeas corpus. So what does it state? This means that the court orders that the arrested person should be present before it. It can also order to set free an arrested person if the manner or grounds of arrest are not lawful or satisfactory. So in this way, the court gives orders. You can say the Supreme Court or High Court give orders to the government, and if it finds that the person, if it finds that the person is being arrested, and he should be present before the court. The second right is writ of mandamus. So this is also one of the important writs. What does it issue? It is issued when the court finds that a particular office holder or particular officer is not doing legal duty properly. So in this right, it is basically issued in the form of command. The command can be either taken a particular form of action or refrain from doing, and is backed with legal rights and reasoning. So now the third writ is writ of prohibition, and this writ is issued by a high court. That is, it can be high court or a supreme court when a lower court has considered a case going beyond its jurisdiction. That means, as we know, the highest apex court is Supreme Court, followed by the High Court and the local court. If we find that some cases in the lower court, they are unable to be solved by the lower court and it is beyond the jurisdiction, then what happens? This right is issued by a High Court or Supreme Court, and the case which doesn't come under jurisdiction of the lower court, they can go to the higher court or they can go to the Supreme Court. Yes, the next writ is writ of certiorari. So it's a writ issued to lower court when these lower courts have gone beyond the scope of their jurisdiction. That means the court orders a lower court or another authority to transfer a matter which is pending before it to the higher authority or the higher court. And the last writ is the writ of quo warranto. So this writ is issued to a person who has been wrongly appointed in the office of the authority. That means we see many times a person due to some unfair means he gets a job and gets wrongly appointed in an office, and this obligates the accused of the presenting whatever evidence he or she has to the court to support the reason for occupying a particular post. So it means if the court finds that a person is holding office but he is not entitled to hold the office, then it issues a writ. It issues an order of quo warranto and restricts that person from acting as an office holder. That means if by mistake or unknowingly or knowingly a wrong person is appointed, so he can be removed only through the writ of quo warranto. So these are the 5 writs which are issued to the Supreme Court and the High Court by the Constitution for the protection of fundamental rights. Now the thing is, how can a person use this right of constitutional remedies and approach the court? So the Article 32 in our Constitution states that the Supreme Court can accept writs from citizens, it can accept writs from the organization if any of the fundamental rights have been denied to them. That means along with exercising the writs, the Supreme Court can also give other lower courts or even take away the responsibility of jurisdiction from certain cases. That means the Supreme Court has been put at the prime level, at the supreme level, and it can give orders even to the lower courts. It can give them responsibilities, or else it can take away the responsibilities from them also. If it finds that in certain cases the Supreme Court thinks that the case is not being solved by the lower courts, it can take the responsibility of solving the cases, and it can take away the jurisdiction of such cases in its hand. Children, right to constitutional remedies. This is not only the one method through which we can get protection to our fundamental rights, but there are also other agencies like National Commission on Minorities, National Commission on Women, National Commission on Scheduled Caste, Scheduled Tribes, etc., where the protection is given to the women, to the Dalits. Besides, we also have NHRM, that is National Human Rights Commission, which was established by law to protect the fundamental rights and other rights of the citizens.